in violation of revised code section 2923.02. It is my understanding today, Your Honor, that the defendant wishes to waive his right to have the case presented to the grand jury and enter a plea of guilty to both counts in the information. There is no agreement on sentencing. However, there is an agreement between the defendant and the state that the defendant will pay the restitution amount of $1,580. That information was provided to defense. Thank you.
Thank you. Ms. Novotny.
Your Honor, that is correct. Before coming into court today, Mr. Barnes and myself went over the written plea of guilty paperwork as well as the waiver of indictment paperwork. He is well understanding of what this court hearing and proceeding entails today and would like to plead guilty today as well. Thank you.
All right, thank you. Mr. Barnes, how old are you?
19.
How far did you go through school?
I had graduated in 2024 from high school.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Schizophrenia.
When were you diagnosed with that?
It was when I had went to the psych ward, I would say in October.
All right, are you being treated for that right now?
Yeah, I'm currently taking risperidone.
Risperidol?
Yeah, risperidone.
When did you last take it?
Shoot, I took it today.
Does it affect your ability to understand what's going on here?
No, sir.
All right, did you get a copy of the information that was filed in this case?
Yes.
Do you have any questions about it?
No, sir.
You understand you have a right to have the case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
Go ahead.
Sign right there for me, okay? Your Honor, in open court, myself and my client signed the waiver of indictment and passed it to the prosecutor to witness.
Your Honor, for the record, I've witnessed the defendant and defense counsel sign the waiver of indictment in open court. I have signed the same document and I'm handing it back to the court.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to some time to talk with Ms. Novotny, let me know and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After those witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yeah.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yeah.
If you have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings that take place in this case. Do you understand that?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
Do you understand by pleading guilty to this felony in count one that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, sir.
In count one, breaking and entering is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
Count two, attempted breaking and entering is a misdemeanor of the 1st degree. It carries a maximum 180 days in jail and a maximum $1,000 fine. Do you understand that?
Yes, sir.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 12 months and a maximum fine of $3,500. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be either 12 months or the time left on post-release control, whichever is more. Do you understand that?
Yes, sir.
You understand if a prison term is imposed in this case, you are eligible for judicial release.
Yes, sir.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation made by the prosecutor or your lawyer at the time of sentencing?
Yes, sir.
Have you had enough time to talk with Ms. Novotny before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
All right, Ms. Horonik, if the case went to trial, what would you have on the show?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on September 8, 2025, in East Lake County, Ohio, the defendant did by force trespass an AmeriPawn, an unoccupied structure with purpose to commit therein a theft offense. And then on that same date in the same city, the defendant did purposely or knowingly and with sufficient culpability for the commission of the offense of breaking and entering, engaged in conduct that if successful would constitute a result in the offense of breaking and entering. Specifically, on that date in that location, the defendant attempted to break the window of a Sherwin Shooting Sports with 2 different items, was unsuccessful, and then walked down the road to the AmeriPawn location, used a Razor scooter to break the window, did enter into that building, and then fled once the owner became involved. Thank you.
All right, Ms. Novotny, anything to add to those facts?
No, Your Honor.
All right, Mr. Barnes, did you hear what Ms. Horonic said the facts would show if the case went to trial?
Yes, sir.
And are those facts true?
Yes, sir.
What is your plea to count 1, breaking and entering a felony 5?
Guilty.
What is your plea to count 2, attempted breaking and entering a misdemeanor 1?
Guilty.
All right, Ms. Novotny? Have them initial in the margins on page 2 where I put them. That's in there, okay.
Remember this paperwork? I'm gonna have you initial here where it says your psych meds. I'm gonna initial with you, okay? So initial right there. Because he put down there my psych meds that you mentioned today.
Oh, would it be JB?
Yeah, your initials.
All right.
So your first name is Jaden, so J and B. Awesome. And then we're gonna have you sign right here, okay? And then date, today is 2/19/26. Okay, thank you. Take that.
Your Honor, in open court, myself and my client signed the written plea of guilty paperwork as well as initialed where it was mentioning his mental health medications and passed it to the prosecutor, the witness the same.
Would you like me to initial as well by the medication, Your Honor?
No, it's all right.
For the record, I have witnessed the defendant and defense counsel sign the written plea of guilty in open court. I'm going to sign the same document and I'm handing it back to the court.
Mr. Barnes, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present. Ms. Novotny advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, a consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty. And find him guilty of count 1, breaking and entering a felony 5, and count 2, attempted breaking and entering a misdemeanor 1. I'll refer this for a pre-sentence report, psychological evaluation. Sentencing will be March 25 at 1:30, and the bond is continued. Anything else? Ms. Horonic? And a victim impact statement also.
Your Honor, I believe we need to set a bond, as this is an information hearing.
Didn't it come over? Wasn't it bound over?
It was bound over, but was
From the
not
Willoughby Municipal Court, Your Honor.
What was the bond there?
$5,000 personal. So we set it on recognizance.
All right, I'll set the bond at your own recognizance. That means that you are guaranteeing you're going to show up. If you don't show up, then you subject yourself to a new charge of felony of the 4th degree for not showing. Do you understand that?
Yes, sir.
All right. So you're going to fill out some paperwork, and then you can go over to the probation department.